This draft ruling relates to the situation where an order is made by the family court to require a private company to make a payment or transfer property to a person as part of a matrimonial separation. The draft ruling discusses the taxation of the payment or receipt of property. The definition of dividend in the tax law includes any distribution made by a company to any of its shareholders, whether in money or other property. Further, broadly, under Section 44 of the 1936 Tax Act, the assessable income of a shareholder includes dividends that are paid to the shareholder by the company out of profits. The ATO takes the view that any order of the family court that requires a payment or transfer of property to a shareholder of a private company will result in an assessable dividend to the shareholder. This is provided the payment is made out of profits. Such a dividend would be frankable. This is where the draft ruling is controversial. A person who is not a shareholder of a private company but is an associate or a former associate of a shareholder is now considered by the ATO to have received a deemed dividend under Division 7A. This is a complete change of view by the ATO on this issue. Previously, the ATO had a long-standing practice, supported by many private rulings, that a payment, not a property transfer, under a family court order was the discharge of an obligation of the private company. This meant that Section 109J of the 1936 Tax Act applied to exclude the payment from the operation of Division 7A. The ATO has now concluded that no obligation of the private company arises under a family court order made to a matrimonial party to cause a private company to make a payment to the other matrimonial party. The obligation is imposed on the matrimonial party against whom the order is made and not the private company. Accordingly, the exclusion under Section 109J cannot apply. Where the private company is made a party to the proceedings so that an order of the family court can be made against the private company, any payment by the private company does satisfy an obligation. Nevertheless, the ATO considers that the Section 109J exception cannot apply. This is because, in its view, the payment cannot be made on an arm's length basis, which is a requirement of the provision. If the order of the family court against the company is to transfer property, not just real property, there is an obligation, but Section 109J cannot apply. This is because Section 109J requires a payment in money, and a transfer of property will not satisfy this condition. This is a significant change in the ATO's view about the taxation of amounts in difficult personal circumstances. It is debatable as to whether the ATO is correct in all of its views. It should be noted that the changed view is prospective. One, consider clients that are engaged in a matrimonial dispute and also have a private company with accumulated profits. 2, if a matrimonial dispute has not yet been settled, advise the party for whom you are acting and their lawyer of the draft ruling. 3, watch for the finalised ruling to see whether the ATO continues to hold all the views expressed in the draft ruling. Thank you for taking the time to watch this video.